Okay, maybe we can start because we are already running late, and yes, and we already kept Jennifer waiting already for too long. Well, good afternoon and welcome to this session on intellectual property and competition. My name is Antonio Capobianco. I'm from the OECD Secretariat to the Competition Committee, and I had prepared short opening remarks, but since we are running late, I will make my short remarks even shorter. But I wanted to say just a few words as to why we have decided to put this topic on the program of the festival. It's not a new question. I mean, a lot of ink has been used to try and grapple with the relationship between competition and IP. But certainly, in the last years, in the last 10 years or so, we, at least at the OECD, we saw these questions popping up and trickling more and more often in policy discussion of all sorts. I mean, the reasons are probably obvious. We know how IP are increasingly underpinning very dynamic economic sectors, and digitalization has become, of course, part of everybody's life and part of markets, how market works. The role and the importance of intangible assets for the economy has certainly increased. It's an economy which is knowledge-based more and more. Certainly innovation has taken a dominant or predominant role also in the analysis of competition authorities. So it's just normal, these questions on intellectual property rights comes back and on the agenda of policymakers, competition authorities, and thinkers of, on competition policy issues. The other element is that we've seen over the last, again, 15, 20 years, probably important enforcement actions. We've seen a lot of cases dealing with, in one way or another, with IP rights. Think of mergers that were considered to undermine incentives to innovation, settlements in patent litigation, which are as an anti-competitive effect because they were preventing entry, for example, by generics in the pharmaceutical sector, the role of standard essential patents in standard setting. So we've seen a lot of activities, and competition authorities have been sort of confronted with this question more and more often. I mean, digitalization, we'll come back to it, of course, has kept many in Paris, but around the world, and especially in this part of the world, busy, and maybe we'll see what the role is between IP and the digital developments. Now, the questions on are they friends or foes? I mean, this is a competition policy and intellectual property rights. I think it's a difficult question to answer, or maybe theoretically easy, but in practice not very easy. There's a very sort of delicate balancing exercise. On the one hand, of course, competition law and competition authorities enforcing the law give deference to the goals of intellectual property rights, so providing some exclusivity, some protected area to the owner of the rights, to reap the rewards for the investment to developing new ideas and therefore to innovate. But on the other hand, we don't want these rights to be used to restrict competition or for anti-competitive purpose. So the balancing is very difficult to make in practice. Now, the topic is, of course, very vast, very broad, and very complex, and we're very fortunate to have here with us three experts. They come from different side to these questions. I'm going to start with Jennifer Dixon. You see her online. We are sorry that you're not here with us in Rome. It's a wonderful time of the year to be here, but maybe next time, Jennifer. Jennifer is the Assistant Chief in the Competition Policy and Advocacy section and the Special Counsel for Policy and Intellectual Property at the US Department of Justice. So welcome, Jennifer. Here next to me, there is Valeria Falce. Valeria is a Jean Monnet Professor in Digital Transformation and AI Policy at the European University of Rome. Benvenuta. And benvenuto also to Giovanni Napolitano. Giovanni is a Director of IP and Competition Policy at WIPO. WIPO is the World Intellectual Property Organization, and he has a long history before joining WIPO here in Rome with the Competition Authority. So we thought to spend 20, 30 minutes until you decide that maybe it's time to go for a nice walk. And we thought about the many issues that we could discuss to pick a few. And I will start with one which gives me at least an opportunity to do some advertisement to a recent work of the OECD, which adopted last year a recommendation on intellectual property and competition. And we know that many agencies around the world have been very focused and spend a lot of resources and time in trying to provide more transparency, predictability to firms to understand when and how, what is this thin red line between sort of what they can do under the intellectual property right, what they do becomes or has a risk or potential of restricting competition, and therefore exposes them to regulatory intervention. I mean, the United States have guidelines, the EU has also rules, but other jurisdictions have that as well. The OECD has taken a little bit stock of all of that work, and we adopted a recommendation which is really tries to provide some guidance to governments. Of course, the recommendation is addressed to governments on this relationship between competition and IP. It's a principle-based recommendation, an instrument. It does not distinguish between the different intellectual property rights, whether patents or copyrights or others. So it takes really a broad approach, tries to offer guidance to some of the questions that policymakers have, and hopefully provides a framework to answer, to start answering future questions. As we know, this is an area where new questions come up every time. If you look at the recommendation, I really would not go into great detail, but encourage you to take a look if you're interested in this area. There are 5 building blocks. Enforcing competition law with respect to IP-based or related business practices. There's a lot about licensing of IP rights. There is a section which is probably very interesting on remedies, IP-related remedies. There's a lot of experience in competition authorities case law on that. Of course, could not have a section on cooperation and coordination, but there is a section on transparency and legal certainty. And that's where maybe I can start with you, Giovanni, because you look and work at many jurisdictions around the world. WIPO has a very broad membership. Many jurisdictions have guidelines and guidance, provide guidance. Some don't, but are thinking to adopt some guidance. What's your perspective on these question of are guidelines on IP and competition effective? What is the role of international organizations like yours or like the OECD?
Thank you, Antonio. So let me start by saying what WIPO is and why we are interested in this area. We are a United Nations specialized agency like UNESCO or the World Health Organization. And our main task is to provide services to the private sector. We help inventors and creators to protect their works internationally. We are the only UN organization that is self-funded. And about 15 years ago, there was a request, mainly from developing countries, that WIPO start working on the relationship between intellectual property and competition. And in fact, I would say that while historically intellectual property has been a primary interest of mainly developed countries, more recently it has become one of the elements for competitiveness also for developing and emerging economies. And as part of this development, as Antonio was mentioning, several countries have developed guidelines on the enforcement of IP-related competition cases. Our position on this is that, of course, these guidelines are most welcome, even in jurisdictions that may not have a long history in enforcing competition law in IP-related cases. And this is because we believe that this area is particularly complex. IP in itself is very complex to the point that you don't even have specialists in patents or specialists in trademarks, but within each of these areas you have mainly lawyers specialized in specific areas within the same IP title. So these guidelines are most welcome because they provide some certainty to the business community. And in fact, most of our work is directed at both competition agencies and intellectual property agencies. And our technical assistance is devoted to bringing together these two communities and work, for instance, in workshops on hypothetical cases so that, you know, each of the two groups can start to understand what are the issues from the other communities' perspective. The development of these guidelines, of course, does not mean that there is, or even that there is, that we're supporting necessarily harmonization across all jurisdictions. And in fact, some of these guidelines have a different approach to the same kind of issues. Like, for instance, not all jurisdictions consider that excessive royalties might be a potential violation of competition rules, or that in fact should be subject to competition agencies' review. But in some countries, this is a potential violation, and so it is included in these guidelines. Of course, we don't support one or another approach, but we try to find a common denominator that we think it's important, so that you know, across the spectrum of the different countries or member states, as we call them, there is a general and shared understanding of the importance of the two areas. And in fact, as a conclusion to this preliminary round, our approach is that, of course, you know, both intellectual property and competition, they support innovation and creativity. But in a way, when you look at intellectual property, you don't have to think just about patents. There's designs, there are geographical indications, there's copyrights, there's trademarks. And when you think about the label of that mineral water, you would not see a lot of innovation in it, but yet there is a lot of intellectual property. When you look at windows in shops, the way that window has been designed by the shop owner, that's also intellectual property. And I like to say that intellectual property is a little bit like your mother-in-law. You may not see her, but you can be sure that it's always there. And in this respect, you know, it's important that the two are considered as both protecting, I think, the differentiating element that the creator or a company puts in it. So what intellectual property does, in my opinion, is to protect the differentiating element that it's in the label of a mineral water, that it's in a specific design of a dress, that it's in a patent. And what makes each of these IP titles different is exactly this differentiating element. And when we talk about competition law, which is about protecting the competitive process, I think it is exactly the same concept, because they are protecting the differentiating elements that each company thinks they have as a competitive advantage over the other competitors. And so the two areas are in a way complementary to each other, not only because they encourage competition, because they encourage innovation, but because they are exactly protecting that differentiating element. And that's what these guidelines, I think, do, and that's why we are supporting them. I would stop here.
Thank you, Giovanni. And you mentioned that there are a lot of guidelines out there. You didn't name many names, or we can certainly name one jurisdiction that has a long-standing tradition to provide guidance in this area, and that's, of course, the United States and the antitrust division. So maybe, Jennifer, you can tell us a little bit about the initiatives that your agency has taken in the past to provide more guidance to firms and on this relationship between IP and competition.
Yes, thank you, Antonio. I have to begin with my disclaimer, you know, that the views I express today are my own and not necessarily those of DOJ, the Department of Justice, but I am very happy to be here and happy to share some of the work that we've been doing. you are right, Antonio, that we've had guidance in the United States for a very long time, beginning in the 90s, 1990s, and then just revised again in 2017. And picking up on something Giovanni said, a key and core principle in those that guidance document is that intellectual property and antitrust laws are complementary bodies of law. They both work to promote innovation in different ways. Certainly, intellectual property laws provide incentives to create, and competition laws help to protect that investment in innovation and allow competition to flourish. So very important that we have both intellectual property protection and a strong competition regime that will really protect that investment. Exclusive rights certainly wouldn't be worth very much if anyone could misappropriate them, and if markets were very concentrated and entry was very difficult, and there could be no room to come in with a new and better product. So competition really protects that process. Competition law prohibits anti-competitive conduct, including mergers that may make entry difficult. And we've certainly seen and had competition enforcement actions in a number of areas involving intellectual property and creators, including technology markets, digital markets, pharmaceuticals, media, entertainment. So having a strong competition regime is extremely important. And I agree that transparency is also important. Firms, businesses understand, what is potentially a problem with respect to antitrust law, and predictability is important. But one area of work that I wanted to talk about that we've been doing is not only having guidance out there for the public and businesses that are operating in the space and developing intellectual property and licensing and really working with intellectual property that way, but also working with our government agency partners and explaining why competition may be important to their regulatory work, and that you should really take competition into account when thinking about certain initiatives that other agencies are engaging in that may affect intellectual property and competition. So just a couple of examples that we've done. We've engaged in some advocacy. We have an administrative process where agencies often ask for comment about the regulatory initiatives. So we filed a couple of comments last year that I think speak to this issue before the U.S. Patent and Trademark Office, and one comment had to do with patent quality, that the PTO was thinking about ways to improve patent quality and certain procedures in their office. So we filed a comment explaining how important patent quality and strong patents are to competition and entry. And we also supported, an initiative that they were taking to have more conversations with the FTA about pharmaceutical patents. And, we really applauded those efforts and filed a comment and shared our competition perspective about why, quality patents and are important, and why generic entry is important to competition. So that's one example. Another example was the PTO was thinking of changing some rules with respect to how you became a member of the patent bar and opening that up to more diverse applicants that had different backgrounds, particularly in the design patent area. So we supported those efforts as well and said, you know, it's really important to have that diversity and have a choice for innovators that are trying to you know, patent their intellectual property, and to have you know, the resources to do that, and to be able to have different options and more options. So that's good. That is good for competition. So, you know, it's not just the core, I guess, competition issues that we typically think about, like licensing and exclusive dealing and things that often come up in intellectual property, but also this idea of working with other agencies and sort of promoting the competition message in that way. So that's...
Thank you. Thank you, Jennifer. Thank you. Yeah, thank you, Jennifer. I would like to bring now in the discussion Valeria, but from a different angle. I mean, you as an academic, you have done a lot of research on competition in digital markets. You've written a lot, you've thought a lot about it. Now we're moving into the AI world. Some of the issues are similar, some are different. And maybe you can tell us a little bit from your perspective, what is the role of intellectual property in the digital world, and whether, for example, the regulation that Europe has adopted recently on AI, for example, addresses these interface between IP and competition.
Grazie. Thank you, Antonio. Thank you for being here. Well, I have, of course, an academic background, but I also had the honor to contribute to the European negotiations. I've been appointed as the national coordinator. So I had the chance to advance the national position towards the relevant negotiation. So I will answer straightforward to your question, and then I will try to elaborate a little bit. The AI Act that does not address very often as expected intellectual property nor competition issues. Let me elaborate a little bit more. In order to address your question, it is important to clarify the starting point. The AI Act is not intended to provide a European Union code on artificial intelligence, meaning that it is not intended to provide a comprehensive legislation on artificial intelligence. The ambition of the AI Act is much more limited. The AI Act, as we know, intends to provide the legal framework, the regulatory legal framework to introduce, to commercialize AI systems and models in Europe. But that's the reason why IP rights and competition issues are seldom addressed. More specifically, trademarks are addressed just with the view to identify prima facie the provider of an AI system. Why the identification is essential? Because, of course, the provider and those actors who belong to the AI value chain shall be submitted to some provisions, to some prescriptions, to some obligations, if and to the extent that a system or a model is highly risky for the European values. When we come to confidentiality and to trade secrecy, well, references are a little bit more extensive. So the AI Act refers to confidentiality in order to clarify that those transparency obligations that are set for providers and for value chain actors are not intended to interfere with the confidentiality and the trade secrecy. Even more, when enforcers deal with possible conducts not complying with the AI Act, they are obliged to make reference to confidentiality, and they need to be sure not to share sensible information. References to copyright are even more extensive, and here let me add a little piece of information. Copyright has fueled the debate and the institutional negotiations over the last round. So the European Parliament stressed the relevance of copyright vis-à-vis providers of foundation models. Why? Because foundation models are those requiring extensive continuous pre-training, as one of the recitals of the AI Act makes it clear, to quality inputs correspond quality outputs, meaning that if AI models are trained with good data, quality data, protected data, well, the output will be more reliable and more accurate. So the interaction with the copyright here is direct, and it is direct under different level. First, the AI Act makes it clear that this regulation is not intended to interfere with copyright, so the AI Act confirms its coherence and its compatibility with the copyright. Second, it states that providers of AI models shall actively comply with the copyright regulation. This is a step forward, meaning that with Article 53 of the AI Act, providers of AI models are subject a new de facere obligation. So they are obliged to introduce technical and organizational measures in order to be sure to comply with the copyright. I will be very quick on that because we are all familiar with the very nice provision set at Article 4 of our 2019 directive, copyright directive, introducing at a union level the so-called text and data mining exception. So in this respect, once again, the AI Act says, yes, there is this exception. This is very important in order to speed and to sponsor new technologies. Be sure, dear provider, to comply with the copyright directive. And here we can face a jump into a specific competition issues. Under recital 106, the AI Act clarifies that copyright shall be respected under the same terms despite the relevant jurisdictions. Why? Because we want to be sure that Italian, European and international providers of Gen AI shall commercialize their models and systems within a uniform and competitive legal field. To sum up, yes, the AI Act could have been more structured in its intersection with IP rights and competition. There is a reasonable explanation why it does not address so often and so much in depth the interaction with IPs and competition law issues. A step forward is made at G7 level, next week, Rome will host the G7 Competition Summit, and I have the clear impression that the interaction between Gen I and copyright will be addressed under a specific competition law perspective, maybe addressing a possible topic that could be monopoly power. Thank you.
Thank you, actually. And maybe this is a good moment to bring Jennifer back in, because of course, the US has not chosen the regulatory road to address concerns in digital markets or emerging AI markets. But of course, agencies and policymakers are very interested in the relationship between competition in digital markets, competition in AI. And you know, the Antitrust Division has recently organized a very interesting workshop. And you mentioned, going back to the last point that Valeria made, that there was an interesting panel on creators' rights and how monopoly power can affect IP holders. Maybe you can tell us a little bit what the discussion, how the discussion went.
Sure, I'd be happy to. Yes, in May, we had a workshop, the Antitrust Division, along with Stanford's Graduate School of Business and their Economics Institute. And the workshop, addressed a number of competition issues that have to do with generative AI. We talked about the benefits of open model weights, how to address access to chips when their supply can be difficult, the balance between access to training data and creators' rights was certainly one of them, and then how to really think about regulation of AI. So with respect to creators' rights and the intellectual property aspects that are sort of at the forefront of these issues, we invited a number of panelists, and it was really terrific because they had a lot of experience in the media industry, entertainment industry for many, many years. And we really heard this concern about how generative AI is making use of creative works. They were concerned about the uncompensated use of copyrighted material that's being used to train AI models. They worried about undercompensation and really analogized to the journalism space, where a lot of journalists have found it difficult to receive compensation for online news. So it was good to hear their perspectives, and why is this a competition problem, you might be asking. And Antonio, you're right, it is a monopoly problem, which is a buyer problem, a buyer power issue. So monopsony or buyer power could be used to really undermine creators' rights. And the Assistant Attorney General for Antitrust, made the point at this conference, and then he said the same thing subsequently, that AI firms could really use their buyer power to the detriment of these creators, and really this concentration in few powerful buyers, AI firms, can harm sellers of intellectual property. So this is an issue, that I think the competition community is looking at. The antitrust division certainly is looking at it. And we just want to make sure that there's that incentive out there to continue to create. And if we want to train AI models, certainly we want to have those creative works available and continue to have incentives to supply them to the public. So, we are watching those issues. I wanted to mention too that the Antitrust Division, the FTC, the European Commission, as well as the CMA, the UK Competition Authority, all put together a statement of policy principles about AI. And in that statement, addressed some of the competition issues at the intersection of AI and competition, but included in that statement, just flagged this issue about monopsony power as a potential competition concern. So, we are looking at the issue. We're also monitoring, possible solutions. Panelists at the workshop talked about licensing possibilities, that are going on right now. There could be both voluntary licensing, perhaps statutory licensing, and certainly intellectual property licensing, as we just discussed, raises competition issues. But for the most part, licensing is analyzed under a very flexible analysis that weighs harms to competition and also considers the benefits. So those are some of the issues we discussed during the workshop.
Thank you, Jennifer. And I think that's opens up the possibility to move to the last part that we had planned. And I know we ran out of time 5 minutes ago, but if you bear with us 5 more minutes, I had just a couple of questions. And one is precisely maybe follows from what Jennifer was saying, the ability also of agencies to properly assess cases when IP is involved. And not many know, I didn't know before Giovanni told me that WIPO actually sits on a lot of data, IP data, that can be a good resource for enforcers when they're assessing mergers or dominance cases or even advocacy efforts, market studies, and so forth.
Yes, in fact, we all sit on a lot of data because these are all public data. The only thing is that whether it's trademarks data or patent data, they're not so easy to put together in a way that could be used by, let's say, competition agencies. Like, for instance, you can have a specific company that files a patent under its name in the US. You can have Apple Inc., you can have Apple Ltd. Sometimes you have the name of the inventor and not the name of the company, so you have to somehow trace back where the inventor works and put it under the Apple box. But one thing that we're doing is, in fact, as Antonio was mentioning, is to complement the data that usually competition authorities use to assess, for instance, mergers, in order to give a better picture of where the emerging companies are in terms of their actual market power. And this is, in my opinion, very important for mergers because you're making a decision now that will have an impact for the foreseeable future. And to get data that would give you an idea of where companies are going in the future is also useful to better understand what might happen once the merger is finalized. And one thing that we're doing is not only to look at patent data, because patent applications, in a way, they come at the end of the research and development process. We are also looking at trademark data, because when a research project starts, one of the first things that researchers do is, how do we call this project of ours? And shall we get a logo or something for this project? And this is one of the first things that they do. And of course, they protect it. So they give it a name, they give it maybe a logo. And once you do that, that has to fall into a specific product category. So you already know now where the company is working. They may or may not file a patent in 5 or 6 or 7 years, but you already know that they're working in a specific area. And if you can map what companies are doing in different areas, the emerging companies are doing in different areas, I think that could be a useful complement to give you a better idea of the competitive positioning of these companies. And in fact, what we are also mapping is not only what the companies are doing, but with whom they are working, whether it's co-patenting or trademarking something together. Sometimes they work with research institutes, and that also gives you an idea of how pervasive might certain research project be. And just one thing about generative AI, because we issued a report a few weeks ago, and yesterday we were talking about how Europe is kind of lagging behind in general in artificial intelligence market or in innovative markets. And in fact, one of the data in this report is that the top 12 patent applicants in the world for generative AI, 8 of them are Chinese, 2 of them are American, 1 of them is Japanese, and the other one is Korean, South Korean. So there's no European company in sight, and hopefully some of the regulations that are in place will encourage companies to invest more in AI in general, and in particular in generative AI. But the prospects for the time being are not particularly good. So hopefully there will be a significant investment in this area, at least from the European side, to increase the competitive level. Thank you.
Thank you, Giovanni. One last question, and I'll leave Valeria take the time she wants to answer that, but your responsibility. But being in Rome, we thought, we want to look at the experience of the Italian competition authority, which is not unique. I mean, other jurisdictions out there have provisions on the abuse of economic dependence. Those can be used in IP-rich environment with some success. Maybe looking at what the competition authority has done here can be interesting as an example for others as well.
Thank you, Antonio. I will address this question from a regulatory viewpoint and not from a competition law perspective, because in addressing digital markets, Italy actually has done a step forward. We in Italy already have from a long time the regulation against abuse of economic dependence. What is new is a 2022 amendment that expressly tackles digital platforms. This provision has been criticized quite a lot in its inception, in its negotiation process, and also in its output. And last but not least, in its competition law enforcement recent judgment. So what has been the novelty, and which is the critique addressing? The novelty is related to the fact that within a contractual relation between a negotiating party and a platform with significant power, well, Italy introduced a rebuttable presumption according to which it is presumed that the platform holds an economic power, a contractual economic power towards the other party. It is a rebuttable presumption, meaning that the platform, of course, can prove that there are other sources, there is no dependency, this asymmetric relation can be overcome. But it is true that in Italy, this presumption, even if rebuttable, has been contested and questioned quite a lot. Despite the critiques, the provision has been introduced, and actually also the types of conduct have been enlarged. So the Italian statute dating back in the 1980s has been enlarged also in connection to conducts, when these conducts are carried out by platforms. And actually one of these is strictly related with data access, data provision, and the disclosure of relevant information concerning the quality of the service. This provision had over the year different enforcement applications. For a long time, the relevant côté was a civil law côté, meaning asking a civil law judge to provide for remedies. More recently, the enforcement has broadened a little bit, adding to the civil law côté the competition law côté, which arises if in addition to contractual remedies, also an impact on the market arises from that specific conduct. So the conduct exploits its effect beyond the contractual relation, so that to affect the market. Also, the competition law côté has been explored in different decisions by the Italian competition law. Most recently, an IP case arose. So it has been a courageous effort. It was related to collecting societies and to renewal of licensing. It was related to economic conditions. It was related to the primary collecting society in Italy vis-à-vis Meta. The decision came to an end in the sense of identifying the Meta conduct as abusing the relative position vis-à-vis the CI, the Italian collecting societies, but there is a but. The case has been annulled by the Conseil d'État, the Consiglio di Stato. It is important to say that the relevant ground was, in terms of a burden of proof, was not related to, how can I say, to the scope of the statute, to its justification, and to its possible implication and applications. So the case law has been clashed on its own facts, and because the standard of proof, according to the judge, was not completely reached, it is a fact that the provision, it is a possible means in order to consider competition law issues vis-à-vis IP rights. I will leave you to a question, since this statute, the abuse of economic dependence, has been questioned not only in Italy because of this prima facie, so rebuttable presumption, but also at a European level, since many stakeholders envisage some key issues in its interaction with other regulatory provisions, such as those included in the DMA. This topic has not been solved yet, so I also hope that in the coming G7 concerning competition, this interaction will be mainly and more specifically addressed.
Very interesting case and questions that it raises. Unfortunately, we have run out of time for sure now. Just an opportunity to ask a question or a comment before we close. We're clearly late. I don't see any hands up, so I think we can close the panel. And please join me in thanking, first and foremost, Jennifer, who wake up very early to be with us online, but also to Giovanni and Valeria for their comments and their discussion. Thank you very much.
Thank you.